Come on. There we go. All right. Back on the record on State versus Loyd. He's present with his attorneys. State Attorney's Office is present. This is the state's motion to use the federal conviction for mutiny.
Yes, Your Honor.
As an aggravator, prior violent felony.
Is my computer mirrored to yours up there, Your Honor?
It says, please wait for the host to start the
Okay.
meeting. So it says start 1:30.
Okay.
It's extremely, I use Zoom a lot. It's extremely picky about the start time. So let me turn the volume up. There you go.
Is that the courtroom audio that you just turned?
Yes.
Thank you.
I turned it up to max.
My webcam.
All right, I'm ready when you are, other than the Zoom is not connected yet. But if you want to start without the Zoom, it's fine.
So are you asking for legal argument at this point? 'Cause I
Oh, no.
have one witness, the defense has one witness.
Well, that's fine, we can
Okay.
wait, no worries. I didn't know if you had something else to present prior
No, Your
to
Honor.
the Zoom witness.
We have a variety of exhibits that you can limited as clarification. And I have no objection to, for purposes of this hearing, moving all these exhibits in.
Okay,
Defense, it's marked as J. Or, you want to mark as J for purposes of this hearing? Yes. Okay.
all right, so J will be received without objection as defense exhibit number 1 for purpose of this hearing only. Have you started the meeting? Have you opened the meeting?
I have.
Yeah, it's not.
He's waiting for the host, which I believe is the court reporter's office.
Oh, okay, all right.
she hosted the meeting?
Yeah, my,
Okay, then we're gonna have to use your computer then, because I don't have the ability to log in as a host. Oh, wait, maybe not. No. I apologize, Your Honor, I didn't realize that.
No problem. Do you all have a court reporter on that end to swear in these witnesses, or?
I don't believe so, Your Honor. Thank you, Ruth.
hey, Eric, hold on a second.
I have a green screen.
What?
I have nothing. I have a green
Doesn't
screen.
have anything on the screen.
Let me get out and reconnect and see if that does it. Hold on.
Well, it's not, this is the same problem we had when we tried to do
Right.
it before.
If you're in on your computer, can we just switch and use your computer?
I have a green screen.
Yeah, we're gonna try to, are you in?
Here, let me simplify this. Do any of you have, let me see if I have a Zoom
Yeah, I think we're
connection.
gonna be okay, Your Honor.
Do you guys have the meeting number and the password?
I do not, you have all that. Yours should be mirrored now.
All right, let me try. Yeah.
Turn your mic off. No, your computer.
Yeah, yeah. Mr. Lemon, you have to mute your computer mic. And the witness needs to turn their video on.
Eric, can you hear me?
Oh, yeah, I'm here.
Turn your video on for me.
Yeah, I can hear you fine.
Turn your video.
My video?
Yes.
I was seeing you a second ago. Let me see. Start video. Okay.
There you go.
Yeah, there you go.
Okay, I think we're good to go, Your Honor. Can you see and hear him?
I can. All right. Call your first witness.
The state calls Eric Stokes.
All right, the person who's appearing on the Zoom screen, does the state recognize him to be Eric Stokes?
Mr. Stokes, do you have an ID? I've spoken to him on the phone. I've not seen him in person.
All right. So I'm looking at his law enforcement officer ID. Sir, can you raise your right hand?
Eric, raise your right hand.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Can you hear me?
Can you hear the court?
No, I'm turning it up just a little bit. I'm sorry. Go ahead.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. You may inquire.
Thank you, Your Honor. Can you please state your name for me, sir?
My name is Earl Stokes.
Okay. Where do you work now?
USP Atwater, California.
And what is that?
What is it? It's a federal penitentiary.
How long have you worked there at Atwater?
Well, that did not go well. Mr. Lenneman, you're not allowed to touch your computer anymore. All right, take that away from him and reconnect, please.
You're the host, so if you shut down. Yes, because you're hosting it. You just ended the meeting. Okay.
We got disconnected for a second.
Okay. There you go.
All right.
Mr. Marrero, can you please?
Okay, Officer Stokes,
Yes.
can you hear me?
Yeah, I can hear you.
Okay, great. Hold on one second.
There you go.
All right, I think we're good, Your Honor. I apologize.
No problem. Go ahead.
All right, Officer Stokes, how long have you worked at the U.S. Penitentiary in Atwater?
A little over 15 years.
And back in, let me direct your attention back to February 23rd of 2007. Were you working there at that time?
Yes.
What were your duties back in February of 2007?
I was a correctional officer.
As a corrections officer, did you have personal interactions with inmates on a regular basis?
Every day.
Did you work with another corrections officer named Officer Perfecto at that time?
Yes, I did.
And what were his duties?
Same. He was a correctional officer.
Did you work on in the same pod or same area of the prison as Officer Perfecto?
On that day, yes. He was adjacent to me. He was in the Bravo side.
Okay. Can you explain to the court how the sides of the pod that you and Officer Perfecto were situated?
So basically, it is considered a unit. There's an Alpha side and a Bravo side. They are connected by a small hallway, which are back then were secured. And at each side, there's approximately 120 inmates.
So how many corrections officers were assigned to each side of that pod?
Back then, it was one each.
Okay, so my understanding that you were in charge of one side of the pod and Officer Perfecto was in charge of the other side?
That's correct.
And each side had about 120 inmates?
That is correct.
Okay. You said there was a hallway between the two pods. Were inmates able to walk back and forth through that hallway between pods?
Not freely.
One more time?
Not freely.
Not freely, okay. Was there a separate door that went into each of the pods?
Yes, there are 3 entries to each unit, or at each side of the unit. That side has a counselor door that is the connecting hallway that you can enter the unit. There's a secure corridor that you can enter the unit, and then there's a compound side that you can enter the unit. And that's the same for each adjacent unit, A side and B side.
Did each officer have a physical key that was used to open the doors?
Yes, they have the ability to go out any of those 3. However, in those days, we didn't have the ability to meet up together with the same keys in fear that if there was a riot, they could take over the whole unit, the A and the B side.
Okay, so am I correct that if you had your own key that gave access to, say, pod B, you couldn't use that same key to get into pod A?
That is correct.
And vice versa, obviously?
Yes.
Okay. At some point on February 23rd of 2007, did you receive word that Officer Perfecto needed some help?
Yes. There's a thing that's
Hold on, officer.
Mm-hmm.
Okay. There was an objection,
Yeah.
then you should stop. At some point, did you get word or receive information that Officer Perfecto needed help?
Yes.
And how did that information get to you?
It is disseminated via radio from control. The radios have the ability to what is called a hot mic, and then control will notify what they hear to the rest of the institution for responding staff.
And what do you mean by a hot mic?
It's called a body alarm. It's a button that's located on top of the radios that can be initiated when something's going bad by the officer.
So an officer sees a situation, that officer can activate the body mic, which then control will hear,
Yes.
and then control can disseminate that information to the necessary people.
Yes.
Okay. Once you heard that Officer Perfecto needed help, what did you do?
I tried to respond. However, all I could do was look through a window.
Okay, describe where you were when you first heard that Officer Perfecto needed assistance.
I was on the adjacent side, and when I came through that corridor or that small hallway that I described earlier, I came up to his door, which I did not have keys back then to access, and I had to observe pretty much what was going on.
And when you got to that door looking into the pod that Officer Perfecto was in charge of, what did you see?
I seen an inmate picking up and slamming him
Okay,
multiple times.
hold on.
This is irrelevant, Judge, because if you follow the case law in Florida, they cannot bring in things that were uncharged. There was a negotiation from an assault on a corrections officer down to mutiny, which is considered, when you hear from my witness, a non-violent crime. So all of this is irrelevant. The courts make very clear this cannot be brought to the jury.
Your Honor, in order to make that legal decision, I think the court needs the testimony as to the facts based on all the case law cited in my motion.
Right now, I think that's I think your objection is at the end, not right now. I don't know what happened, so I need to hear what happened, and then I'll make a decision as to what was relevant and what isn't. So, go ahead, you can answer the question.
Okay. So Officer Stokes, what did you see when you got to the door that led into Officer Perfecto's pod?
That he was being picked up and slammed to the concrete multiple times.
About how far away would you have been from this?
Maybe 40 to 50 feet.
And are you able to see this through the closed pod door?
Yes.
Okay. How were Officer Perfecto and the inmate positioned when you first saw the two of them?
The inmate, I could see his right side, and the officer was on the ground after that was done.
Okay. Did you see how the officer got to the ground initially?
After seeing him being slammed to the ground.
Okay. So am I correct that when you first saw these two individuals, were they standing or was one on the ground already?
One was standing.
One was standing?
Yeah, it was the inmate was standing.
Okay. When you first saw them, Officer Perfecto was already on the ground?
Yes. Well, no, not when I first saw them. When I first saw them, he had been picking him up and then he had slammed him.
Understood. Okay. After Officer Perfecto was slammed to the ground by this inmate, what did you see happen then?
All I seen was him just like he was helpless.
Okay. Was it only one time that Officer Perfecto was slammed to the ground, or were there multiple times?
No, it was 2 to 3 times.
Okay. Were there any other inmates in the immediate area when this was going on?
Yes.
Okay. Did this happen in like a common room area where inmates were able to frequent?
It's called the flats. It's where they all can basically hang out, watch TV, sit, play games, whatever. So everybody was in the unit at that point.
When you saw this happening, what did you do?
I started kneeling and slamming the door to try to distract as much as I could because I was helpless. I couldn't really get in there.
And what happened when you started kneeing and kicking the door?
They stopped for a moment, and at that time, Officer Perfecto got up and ran to the door.
What did the inmate do?
Just kind of paused and was yelling.
Once Officer Perfecto got to the door, what happened?
He opened the door, and I pulled him in, and I just said, stay, and I took off running into the unit.
And when you ran into the unit, what happened?
Other officers were responding from the adjacent door from the compound, and we around.
And you did what? I'm sorry?
We placed the inmate on the ground and restrained him with restraints.
So was the inmate eventually subdued and I'm assuming taken away to a different location?
Yeah. We take them to the lieutenant's office and then through medical to be assessed.
And what was the name of the inmate involved in this?
This was inmate Markeith Loyd.
Okay. Now, after this incident, I'm assuming there was some documentation that had to be done to document the incident, right?
Yes.
Did you?
Oh,
go ahead.
No, I'm sorry, go ahead.
Did you write any kind of a memorandum or a statement?
Yeah, the best that I could.
And have you seen that memo?
Just recently.
Did you, after reviewing that memo, did you include a great deal of details about what you saw before you personally became involved?
Not all details.
Why not?
I was still a rookie, and I had not even went to schooling yet in Glencoe, Georgia yet.
Okay. So you didn't include that amount of detail?
I didn't have the proper training for the layout to do the memorandums. I just did the best that I could at the time.
Okay. Any doubt in your mind that you saw inmate Markeith Loyd grab Officer Perfecto and take him down to the ground?
100%.
Okay. No further questions at this time, Your Honor.
Officer, are you still an officer?
Yes, sir.
Okay.
Oh, an officer.
You first testified he was taken down and picked up a second time. And then at some point when he was asking you about what happened, you said the first time you saw him, he was on the floor. Isn't that correct?
first time he was in motion to the floor. He went to the floor, yes.
So is it your testimony that you never said the first time you saw him, he was on the floor?
What I seen was him being slammed to the floor.
And you actually put in your report, which was dated to February 23rd, 2007, to Lieutenant White, that you observed inmate Markeith Loyd standing over Officer Perfecto from 2B's team door. Officer Perfecto stood up and came to the team door and entered, while the responding staff entered from the compound Sally door. Isn't that what you put in your report?
That's partially correct. What I stated was that myself and the responding staff came into the unit, and at that point, he did stand up and come to me. That's after I had made an attempt to distract him by kneeing the door and slamming on the door.
Well, let me read your entire report. On February 23rd, 2007, at approximately 7:30 p.m., I responded to 2B's body alarm from 2A. I observed inmate Markeith Loyd, 23539-018, standing over Officer Perfecto from 2B's team door. Officer Perfecto stood up and came to the team door and entered, while the responding staff entered from the compound Sally Port door. I then entered the unit of 2B. Inmate Markeith was yelling, "It's not a war on drugs, it's a war on us. They are coming for us." Inmate Markeith came towards me, and Officer Almana, Lieutenant White, and I gained control of the inmate by placing the inmate on the ground. I applied the handcuffs, while Officer Almaza applied the leg restraints. The inmate was removed from the unit by responding staff, and there is nothing further to report on this incident. That was your report that you wrote, right?
That is correct.
Now, you were a corrections officer back then, right?
I was a correctional officer for a few months.
And so, as a matter of fact, you were trained before you became a correction officer how important it was to prepare reports. Isn't that right?
No, that is not correct. I had not been to Kalenko. I was never an officer prior to becoming a correctional officer.
And so, when this ended up getting charged, were you ever told that Officer Perfecto didn't want anything to do with this? Did he ever tell you that?
No, not at all.
Judge, the only thing is I'd move in his report as evidence for the court to
It's
consider.
already been stipulated in, huh?
No, that wasn't part of it, but I want to,
Just for the record, I have no objection to the statement with the statement coming in.
All right,
For
that'll
the
be
purpose of
admitted,
this hearing only.
and that'll be admitted as defense exhibit number 2 for the purpose of this hearing only.
I have nothing further of this witness.
All right, redirect.
No redirect, Your Honor.
And this witness be excused.
Yes, Your Honor.
All right, thank you, sir. You are free to go.
Thank you, Officer Stokes. You can sign off, and I believe there's another witness, Eric Kirsten, who's for the defense.
Yes.
Does anyone have a statement?
I do, I just have to be.
I can give you my copy, Your Honor.
Okay.
Can I see? Oh, sorry, thanks. Thank you.
All right. So for the record, the statement's now been handed over. All right, so you have no further witnesses, Mr. Preston?
I have no other witnesses for
All right.
purposes of
Call your first witness, Mr. Williams.
Eric Kirsten, Judge, can I get him big on the screen? How do you do
When he
that?
speaks, he should be.
Okay.
When he speaks, he'll pop up. Mr. Kirsten, can you hear me? Mr. Kirsten, can you hear me? Have you guys unmuted everyone? Because I'm not the host, so you have to unmute others for them to be able to be heard.
You need to unmute. Can you hear me, Mr. Kirsten?
Yes, I can hear fine.
Okay.
And you unmuted me.
You are not, I don't believe you're a member of the meeting because it's being broadcast through this computer around here.
I don't know that he can hear me. Can you hear me, sir? Let me try this. Hold on.
Just probably just picked up the microphone on the laptop.
Let me do this. Did our laptops turn off for obvious reasons? Sir, can you hear me? Sir, can you hear me? This is Judge Marquez. Can you hear me? He can't hear a word I'm
Mr.
saying.
Kirsten, can you hear the judge?
I faintly heard a woman in the background. I'm not sure whether that was the judge or part of the court staff.
That was the judge.
I'm not hearing the judge right now.
All right. Do you all recognize him as Mr. Kirsten, or does he need to show me ID? Do you?
I'm fine, Your Honor.
Okay.
I've not met him, but
All right, sir, I need you to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may inquire.
Would you tell me your name, sir?
Eric Kirsten.
And how are you currently employed?
I'm an assistant federal public defender in the Eastern District of California, in Fresno, California.
And how long have you been doing that?
23 years.
Did there come an occasion where you represented Markeith Loyd on a criminal charge?
Yes.
Can you tell me approximately when that was?
I believe it was approximately 2008. I believe the case was filed in 2007 and it was closed in 2009. Another attorney from our office actually handled Mr. Loyd's case for nearly a year. But eventually I took over after approximately 11 months.
Okay. And what was he charged with at that time when you took over?
He was initially charged with assault on a correctional officer.
Okay. Now, we entered several documents into evidence for consideration by the judge, which includes two plea meetings, a sentencing, and I think there's one other document. Were you present during all those events?
The plea meetings and the sentencing, I was certainly present. I'm not sure what the other document you're referring to was, so I can't say for sure regarding that matter.
Okay, so let's go through your involvement in this case. When you became involved, did there come an occasion when the discussion of plea came up with the Assistant U.S. Attorney?
Yes.
And tell me about that.
Well, by the time I got involved in the case, most of the preliminary work had been done by Ann Voris of our office, who she's since married. Her name is now Ann McGlennon, and she's retired from the office. She's in private practice as a panel attorney. But she had done most of the preliminary work. When I came on board, it was really a point of trying to figure out a plea agreement that could resolve the case. I think there was a general feeling amongst everyone involved, including the prosecutor, that the amount of time Mr. Loyd was facing was excessive based on his conduct in the case.
Okay, and tell me what was the concern in regards to career criminal?
They have sentencing guidelines in federal court for each offense. There's a base offense level. Depending on the circumstances around the case, that base offense level is either increased or decreased. And that's on one axis of a chart from 0 to 43. From 0 to 6 on the other axis is a career history, a criminal history. Each time a person gets in trouble, they receive points based on the total number of points. They're placed in a career history, criminal history category. Where those two columns intersect, there's a recommended sentence in terms of months. That sentence is advisory. It's not mandatory on the court, but it's a starting point. And as a practical matter, it's the most likely place the sentence is going to end up. Because the maximum possible sentence was 8 years in Mr. Loyd's case, if he would have been deemed a career criminal, he would have been facing an advisory sentencing guideline range of 36 to 47 months. which actually isn't all that long for a federal case, but we felt it was excessive for the facts. And if we were going to go to, if that's what the sentence is going to be, I think we certainly would have gone to trial in the matter. We were hoping to get something with a lesser sentence. Ms. Voris had attempted to negotiate a misdemeanor out of the case, and the government wasn't willing to do that. So I when I came on the case, my primary focus was finding some sort of alternate charge that could be pled to that would result in a lesser sentence. And that's how the mutiny charge came up, which is, it sort of sticks out in my mind because I've been doing this for a long time, and that's the only time I've ever come across that. I've never seen that charged in any other instance. It's an unusual charge, I would say.
And I asked you, I think we had a conversation, an email last night about whether you knew of any jury instructions that were ever created for that particular statute?
Yeah.
And your response was?
Yeah, there are no Ninth Circuit pattern jury instructions for that offense. I believe I emailed you the elements that needed to be proved for a conviction according to the plea agreement, and I've got that plea agreement handy if the court would like me to refer to it.
So let's talk about the plea agreements. Tell me, well, before we get to the plea agreements, was it an interaction between you and the prosecutor to try to find a case that wouldn't place him in a career criminal exposure?
Yes, because the focus was on trying to get a lesser sentence. We thought the case should resolve, and I know that I practiced as a defense attorney in state court in Arizona before coming over to the federal system. And I know in state court there were a multitude of charges, and there was a lot of flexibility, and we could usually determine what we thought was a reasonable resolution and enter a plea agreement fairly easily. In federal court, there are fewer charges. There are fewer offenses that are set forth. And normally, at least here, and I imagine in most locations, the government's position is they want a sentence within the sentencing guidelines in most circumstances. And so it was trying to find some sort of an offense that would result in a lesser sentence that Mr. Loyd would agree to.
Okay. And did you find that?
Yes, I did.
And what was that?
It was inciting a mutiny. I believe it's 18 United States Code, Section 1792.
Now, there was a little confusion when I was looking through the documents because some of the documents say attempted and some just say inciting a mutiny. Which was it?
I believe it says attempting to incite a mutiny. Frankly, I don't have the statute in front of me, and I'm not sure exactly, but I believe that that's what he pled to. But in the federal system, whether it's an attempt or whether it's a completed act, the sentence would be the same.
Okay.
And here, I think I was going to say, because there was no mutiny, we probably went with the attempt to incite a mutiny.
Now, was there mental health issues that contributed to the decision to reduce the sentence?
Indirectly, I don't think that the government made its plea offer to avoid some sort of a mental health effect.
Hold on 1 second.
But based on the video of the...
Hold on.
Hold on.
What?
Okay.
My objection is relevant for purposes of this hearing.
I can't hear what's being said right now. I can hear noise in the background, but I can't make it out.
My objection is relevance. Whether there's an affirmative defense or mitigation of mental health issues is not relevant to whether this event is admissible as a prior violent felony.
Sustained.
All right. So tell me what the elements of the mutiny charge that Mr. Loyd pled out to and where they are located.
Okay. They're located in the... here. I've got a copy of the plea agreement that was entered into in Mr. Loyd's case in the Eastern District of California.
Okay, could Could you like note so we see, or maybe place the page up to the thing so we can see what it says? There you go. It says memorandum of plea agreement pursuant to Rule 11E. Okay,
Correct.
that was introduced, Your Honor. Go ahead.
Can I have,
And
let me have the packet, please.
on page 2 of the plea agreement,
He can keep talking.
Oh, okay. On page 2, go ahead.
yes, under the nature, elements, and possible defenses section at line 16, it says the government, in order to secure a conviction, the government would be required to prove the following elements beyond a reasonable doubt. First, the defendant attempted to cause a mutiny. Second, the mutiny the defendant attempted to cause would have occurred on the grounds of a federal penal institution. Third, the defendant intended to cause a mutiny. Fourth, the defendant did something which was a substantial step towards causing a mutiny. Mere preparation is not a substantial step towards the crime of causing a mutiny. A mutiny occurs when inmates acting together resist a prison warden or his subordinate officers in the free and lawful exercise of their legal authority.
Okay.
And there was also sort of a bare bones factual basis, which Mr. Loyd agreed to in the plea agreement as well.
Could you read that?
And that was on page 5 of the plea agreement. And the factual basis states, on or about February 23rd, 2007, within the Atwater Federal Penitentiary and in the county of Merced, State and Eastern District of California, defendant Markeith Loyd intentionally attempted to cause a mutiny in a federal penal institution. Defendant Loyd deliberately and intentionally exhorted his fellow inmates to resist the directives of penitentiary staff members who were properly and lawfully exercising their legal authority.
Okay. And that was the complete factual narrative that was agreed to?
Yes.
Okay. When we talked, we went through a couple of things prior to you giving a deposition with the prosecutor. And those things were things that were important to you in regards to this particular plea. Can you tell me those?
I'm not sure specifically what you're referring to, but I know that the main focus in reaching a plea agreement was to get to a sentence that we believed was commensurate with the acts by Mr. Loyd. The guideline sentencing range for this offense was 15 months. The government was in agreement with the recommendation towards a sentence of 15 months. That wouldn't be binding on the court, but still it's a recommendation by the government. And that was the primary focus. The reason for that is that, based on my view of the video of the incident, and I can't speak for the government, but I believe that was their motivation as well. There was no apparent intent by Mr. Loyd to injure the correctional officer during the assault. I believe if there had been an intent to injure the correctional officer, the government believed that happened. There's no way they would have agreed to this plea agreement.
Okay. I have no further questions, Judge.
Cross?
Good afternoon, Mr. Kirsten.
Good afternoon.
If you can't see me, this is Rich Buston with the State Attorney's Office.
Okay.
So the record's clear. The individual that we're talking about that you represented is Markeith Loyd, correct?
Correct.
Date of birth 10/8/75?
I don't know his date of birth, but that seems accurate.
Okay, and it occurred at the federal penitentiary in Atwater, California?
Yes.
Okay, you mentioned in your direct examination that there was a video associated with this event?
Yes. Yes.
And you have a memory of that video, correct?
Yes, I do.
You don't have that video anymore in your file, right?
No, it's been misplaced. I looked for it and couldn't find it.
Okay. And I believe last we talked during your deposition, you were going to put a request in to have some other people look in like a storage facility.
I was in conversations with the branch supervisor of the United States Attorney's Office here in Fresno.
Has there been any success as of today in finding that video?
Actually, I received Kirk Sheriff is the assistant U.S. attorney I was communicating with. I received an email from him last night that they had received the file. They found some video in discovery, but they were having a hard time opening it. I received a message from him that he was going to see if their IT person could open it up because they were having problems.
Okay.
But that's all I know. I haven't heard back since then.
Okay, I appreciate you taking the efforts to follow up on it. You don't have any notes from your viewing of that video in your file either, correct?
Correct.
Okay. Based on your memory of the video, am I correct that it showed the defendant, Markeith Loyd, clearly grabbing Officer Perfecto by the shirt or shoulder area?
Yes, I can't remember exactly how they came together, but my recollection is that Mr. Loyd sort of grabbed his shirt and shoulder and stepped behind Officer Perfecto and sort of pulled him down to the ground.
Okay. So Mr. Inmate Loyd grabbed Officer Perfecto and brought him down to the ground?
Yes.
Okay. And based on your memory of the video, after Officer Perfecto was on the ground, it showed the defendant grabbing Officer Perfecto's feet and spinning him around a little bit, right?
Correct.
Okay. So even by your memory of the video, would you agree that the facts as you remember them show that the defendant made contact with Officer Perfecto's body?
Yes.
And that contact was obviously not friendly?
I'm sure it wasn't friendly from Officer Perfecto's perspective. I don't think there was any intent to harm Officer Perfecto, just to pull him to the ground and create a disturbance.
Okay. Based on that conduct, Inmate Loyd was arrested originally for assaulting a federal corrections officer, correct?
Correct.
And by your analysis of the case and facts, would you agree that the facts would have supported the felony crime of assault on a corrections officer?
Probably yes, because the only physical contact was all that was required. Part of the difficulty in the case was that the indictment actually charged assault by striking or beating, I believe. And there's no way that would have stood, but I believe there was physical contact, and Mr. Loyd pulled the correctional officer to the ground, so I believe that the assault charge would have stood for that reason.
You cut out. Do you believe the assault charge was what?
I believe the assault charge could have been proved for that reason.
Okay. And the crime to which the defendant pled, the instigating a mutiny, is a felony charge, correct?
Correct.
Okay. And in this case, a pre-sentence investigation was done on the case, correct?
Correct.
Have you reviewed that pre-sentence investigation? I believe it was prepared by a federal probation officer on April 3rd of 2009.
I haven't reviewed it since the case was closed. I believe that I mentioned in the deposition. I believe that report was in the same section of the file that contained the video, and so I haven't reviewed it recently.
Okay. The sentencing on this case occurred April 10th of 2009, correct?
I believe so, yes.
And the pre-sentence investigation would have obviously been prepared prior to that sentencing date.
Correct.
And as a federal public defender, you would have reviewed at the time the pre-sentence investigation before sentencing, correct?
Correct.
Okay. Do you have any independent memory of the pre-sentence investigation facts that were contained in there?
No, I do not.
Have you reviewed the sentencing transcripts?
Not recently.
Okay. If you had an objection with the facts as relayed in the pre-sentence investigation, would the sentencing have been the time to make a challenge to those facts?
My focus of sentencing, well, yes. If I felt it was relevant to the sentencing proceeding, that's when I would have made the objection.
And In this case, you did not make any objection to the facts contained in the PSI because it wasn't relevant because you had a sentence, an agreed upon plea to a lesser charge and a sentence already agreed upon, right?
Well, that's partly right. There was an agreed upon recommended sentence by myself and the prosecutor, and I assumed that the probation office was also recommending that same sentence just because I didn't file a sentencing memorandum. If there had been a dispute regarding the appropriate sentence from the probation officer, I certainly would have filed a sentencing memorandum setting forth why I believe the agreed upon sentence was appropriate. Since I didn't file a sentencing memorandum, I feel quite confident that there was a recommendation from the probation office for the 15-month sentence.
And if there was a dispute as to the facts in the PSI, that dispute would have been reflected in a sentencing memo that you would have filed.
If I would have filed a sentencing memo and there were disputed facts, yeah, I would have definitely addressed them in the sentencing memo.
Okay, I think that was a bad question on my part. Would the sentencing memorandum be the proper vehicle to bring an objection to the facts in the PSI to the judge's attention?
Yes.
Okay. And at the time of the sentencing, would you agree that there was no objection to the facts as laid out in the pre-sentence investigation by you to the court?
Yes, I didn't file any formal objections, so that there wouldn't have been any objections to the facts by me.
And there was no objection made by the defendant, Markeith Loyd, at the time of sentencing to the court about the facts contained in the PSI, correct?
Correct.
Okay. Can I have one moment, Your Honor?
Yes.
I don't have any further questions for you, Mr. Kirsten. Thank you so much.
Redirect.
Yeah. Mr. Kirsten, can you tell the judge what a PSI is?
It's a pre-sentence investigation report prepared by the probation office. In the federal courts, the probation office they work for the court. They're supposed to do an independent evaluation of a case and make a sentencing recommendation. If there is an agreement in a plea agreement, the probation office is not bound by that agreement. They make their own recommendation as to what they believe the appropriate sentence should be. They also include facts about the case that they take from discovery, and also personal history about the defendant, sort of his background, his criminal history, a wide range of personal background information.
Do the probation office who does the PSI, do they participate in the plea agreement where a factual narrative is created?
No.
And you said if they have an objection to the factual narrative of the plea, that they would state that in the pre-sentence report.
They make their own, they don't make an objection per se. They just give their perspective on what occurred in a case.
So they're go ahead, I'm sorry.
Yeah, they're independent of the plea negotiations.
And you said they get that information from discovery. That would be documents within the court system.
Pardon?
You said they get the information in the PSI from discovery. Is that right?
Yes, that's correct. Normally, I think the government provides a copy of their file to the probation office.
Okay. And in this particular case, were you confident between the between the plea agreement and the communications with the prosecutor and the judge that this plea was going to happen the way it was agreed upon?
I was confident. In the federal system, judges don't participate in the plea negotiations. They're sort of independent. But since myself and the government and presumably the probation office, I haven't reviewed the report as I said, but since I didn't file any objections, I presume that the probation office was also recommending a 15-month sentence. And since everybody was on the same page as far as an appropriate sentence, I felt it highly unlikely that the judge wouldn't go along with it.
Okay. And so we're clear, the purpose of filing an objection is when your client is put in peril in some way that could affect the sentencing, correct?
Yes, if there was a recommendation for a more severe sentence, I would definitely address the, factual disagreements.
And it's only necessary if you think that it's going to impact your client's sentence.
As a practical matter, yes. If you want to make objections, that's where you make the objections. But if you're facing a sentencing where you're very confident that the sentence is going to be what's anticipated, it's not uncommon not to file a sentencing memorandum. I would guess in the majority of my cases, I'd file a sentencing memorandum, the large majority. And technically, a sentencing memorandum is more social background characteristic type information that would support a lesser sentence. Formal objections would be to the guideline calculations or the factual information. And again, I don't remember what factual information was contained in the pre-sentence report, but I know that the recommendation was for 15 months, and that's what my focus was on.
Okay. Those are all the questions I have, Judge.
May this witness be excused?
Yes.
All right, thank you, sir. You're free to go.
Thank you.
Thank you.
All right, argument, Mr. Buckman.
Your Honor, I will rely primarily on my motion that I filed regarding this issue. I think the Florida Supreme Court has made it clear that the court is to look at the underlying facts of the prior violent felony and not look at the name of the charge. I've cited to you a variety of cases in my motion, including Johnson v. State, 465 Southern 2nd, Gore, 706 Southern 2nd, 1328, a variety of other cases that throughout my motion. One other case I would point out, Reynolds v. State, 934 Southern 2nd, 1128, actually affirmed the trial court's decision to allow the state to introduce details surrounding a prior violent felony conviction, which also included facts that established the committed crime was convicted. My point of citing all these cases is, again, the court is to look to the facts surrounding the prior violent felony, not the name. Though the defendant arranged and negotiated through his lawyer to get a plea to a lower crime, is that crime that he pled is still a felony, which is obviously the first predicate to get a prior violent felony in a death.
Let me get clarification from both of you on something. Did he plead to attempted mutiny? Well, actually, was he convicted of attempted mutiny or mutiny? Okay.
If I could have one moment, Your Honor, I'll look at the actual certified copy of the conviction. It says 18 U.S.C. 1792, instigating a mutiny. That's the certified copy of conviction, which was included in the...
Okay, and then because that and the transcript of the plea are slightly... The plea seems to be to an attempted mutiny, but the adjudication... I can figure that out in a minute. Go ahead. Thank you.
I agree the memorandum indicates a plea to attempt. The certified indicates a plea to instigating a mutiny. I believe the federal public defender indicated that in the federal system it doesn't matter because it's the same punishment and same code, I believe.
Okay.
And for purposes of my argument, it doesn't make a difference whether it's an attempt or completed crime, because again, the court is to look at the facts of the crime itself. I believe in one of the cases I cited, the defendant pled to a lesser offense of attempted sexual battery, and the state later, in the death penalty case, attempted to use that as a prior violent felony. The court said it didn't make a difference as to whether it was an attempt. You look at the underlying facts. So here, the underlying facts in this case are based on the testimony of Officer Stokes. He observed the defendant pick up Officer Perfecto on at least 2 occasions and slam him to the floor. Even if you disregard Officer Stokes' rendition of what he saw, based on the memory of Assistant Public Defender Mr. Kirsten, who just testified, Mr. Kirsten said that according to the video he watched in his memory, Mr. Loyd grabbed Officer Perfecto by the upper part of his body area, went behind him and pulled Officer Perfecto to the ground. He acknowledged that the acts that he saw and the facts that he analyzed as his public defender would have constituted the crime of assault of a corrections officer, because that only required evidence of an unwanted physical touching. So even in the light most favorable to the defense as far as what happened, we have a crime of violence. Based on the case law I have cited to the court, the fact that it is a crime of violence under anyone's explanation, even the federal public defender's explanation, it should be admissible as a prior violent felony.
So you're seeking to admit you're just saying the facts of the mutiny, attempted mutiny, whatever it's called, are the underlying facts are the violence.
Correct.
Okay. Response?
Judge, they spin a web that is legally incorrect. In Mann, provide the court a copy of it, they make it clear they look to the underlying conviction and the record. The record is not what this officer, who I submit perjured himself about, where he wrote in his report one time being slammed down, as he said, versus 3 times. If you look on the page 2, Judge.
Terry, what do you have? What do you
Two of
Oh, I'm
what?
sorry.
Page 2 of Mann?
Yeah, page 2 of Mann.
Sorry, Your Honor.
If you look on the right-hand side, it talks about the prior violent felony, beginning at 581, going down to the end of the sentence. We are not presented with a copy of the Mississippi charge document and thus cannot determine whether it alleged and the jury convicted him of breaking with intent to commit a crime of violence. The record of Mann's conviction, as presented to this court, does not disclose a conviction of a crime of violence. We hold that a prior conviction of a felony involving violence must be limited to one in which the judgment of conviction discloses that it is violent. In this particular case, you can argue that mutiny on its face could be a sit-down directed by Mr. Loyd, or a non-violent activity directed by Mr. Loyd. The courts do not allow the reach back from a charge that is not even designated as a violent charge, and there's no evidence that presents it was a violent charge, Judge. Although the public defender said he thought, yeah, it may be violent, but on its face, it's not violent. And so because of that, Judge, you cannot use this charge as a prior violent felony aggravator.
So there's a case. It's called, let me take this off so make sure you guys can hear me. It's Sweet versus Moore. Sweet is S-W-E-E-T. Moore, M-O-O-R-E. It's 822 Southern 2nd, 1269, Florida Supreme Court, 2002.
What was the last 828? Sorry.
822 Southern 2nd, 1269.
Thank you.
Florida Supreme Court, 2002. And this is what I'm going to ask both sides to address, but since you're up here, you go first, Mr. Lenneman. If you look at footnote 2 of the opinion, the court in this one specifically found prior violent felony aggravator using riot. And the Supreme Court affirmed. They don't actually, it's in the footnote is where you find it. And they found that a riot constituted a prior violent felony. So.
But there's no evidence of a violent before the court.
Hold on, let me finish.
Thank you.
The federal statute says mutiny or riot. So a mutiny, I mean, I know that you say that a mutiny is not on its face violent, but a mutiny is also not on its face nonviolent. A mutiny can be quite violent. So I'm not sure why the fact that the word mutiny is being used would automatically preclude this from being considered a violent felony offense. I get the case you're citing to me. Burglary is not a violent offense. And if you go to trial and you're convicted of burglary but not of the sexual battery, you've been acquitted of that. So that would never be an aggravator. So I understand the case you cited, the man case.
It was burglary with a commission of violence. That was the charge.
Right, but he was
and
acquitted.
And the
of
court said there was nothing on its face or anywhere that put this particular event in the box that would create a prior violent felony.
Mutiny, what is the basis of your argument that there is nothing about a mutiny charge that could be considered on its face to be violent? That's the question I'm asking you. No. Go ahead.
Well, first of all, Judge, I think that the situation needs to be looked at on multiple levels.
Okay.
Prosecutors trying to throw out this testimony from this guard that was inaccurate.
Forget the guard.
Okay.
Just base it on what your witness said. Which
Okay,
was that
so my witness says that when the prosecutor and the U.S. attorney and the defense attorney got together,
right.
they both agreed that this was an overcharge based on the event. He told you...
Overcharge based on the sentence. He did not say it was an overcharge based on the event. He specifically said that Mr. Loyd could have been convicted of the original charge of assaulting a law enforcement officer or a corrections officer. So it was an overcharge based on the sentence he was facing. Go
Okay.
ahead.
But nevertheless, Judge, it was agreed upon by the parties that they would reduce this to a charge to avoid a career criminal, which considers it to be violent. So when he was pleading this charge under the sentencing guidelines, he wasn't facing a career criminal possibility.
Okay.
And so they created this mutiny charge just out of the air to allow him to plead to this. And as you heard, at some point they were even talking about a misdemeanor charge that the U.S. attorney wouldn't originally would not agree to. So what we're talking about here, though, is what is the court allowed to do? Are you saying you're allowed to go, you know what, picking him up and throwing him down is considered mutiny? No. Considered a riot? No. There's no evidence of mutiny or riot here, Judge, at all in the record. The only evidence there is of the picking up and throwing down 3 times and then him being taken into custody. And the court has to look at the scenario to be able to make that decision.
A mutiny, this is from the plea thing, it's been a long day, I can't talk. This is from page 2 of the plea agreement, the memorandum of plea agreement, where it says, a mutiny occurs, that's what it says, occurs when inmates acting together resist a prison warden or his subordinate officers in the free and lawful exercise of their legal authority. So would not slamming an officer to the ground constitute a mutiny?
Absolutely
under
not. Absolutely not.
Because what? Do you have some law that says that, or
Because-
that's just your
because
opinion? Mr. Lloyd,
it's an-
no talking.
Man, you got to listen to my
Listen.
back while we.
Mr. Lloyd, we are not listening to you right now. Go ahead.
Judge, if I can see that document, because I don't have mine.
Oh, this is what you filed.
Yeah.
It's the first orange tab.
Okay.
Don't write on this. This is the actual exhibit. I
Of
just
course.
tabbed it so I could get to it. If you need a minute, I'll give you one.
Judge, none of these elements on second, third, and fourth have occurred or were proved up. Second, the mutiny the defendant attempted to cause would have occurred on the grounds of a federal penal institution, which is true. The defendant intended to cause a mutiny. There is an intent element. There's no evidence that he intended to
That's
cause.
what he pled to.
No, I understand that, Judge.
So I can't use now your argument, now you appear to be arguing to me that the court cannot use the facts of what occurred that led to the plea, and I also can't use the actual plea agreement?
No, what you can't use, Judge, is the facts that they put forward to determine whether a mutiny occurs when inmates acting together, there was no inmates, there was one person, Markeith Loyd, acting together, resist a prison warden or his subordinate officers in the free and lawful exercise of their legal authority. There's no evidence that there were inmates acting together. And more important, that particular sentence can be filled with multiple nonviolent presentations. Sitting in, refusing to eat, refusing to get up.
And none of those facts were present here. What was present was him, I mean, even your witness doesn't deny that he put his hands on a law enforcement officer and took him to the ground.
But at the end, Judge, my client ended up pleading to something lesser, and you cannot use the facts from that to throw them into a mutiny. There's no factual support.
He pled to a mutiny.
No. What I'm saying is you're using the violent act.
Right.
They discounted the violent act, Judge. They didn't say that that was part of it. It was never part of the proffer. It was never part of the plea agreement. It was never part of the sentencing. There was no discussion about you picking up and throwing down this person, this guard, in any manner. None of that was used. You're trying to backdoor this event by saying, you know what, I think this is good enough to call it a mutiny. And, even though it doesn't involve, inmates acting together, I'm going to just say that it fits the bill. It doesn't, Judge.
Yes.
I mean, there's no question what
Any
it
other
said.
argument from you?
I'm sorry?
Any other argument?
Yeah, Mr. Loyd wants me to.
No, I'm not. Mr. Lloyd is not a lawyer, so
Okay.
I'm just listening to lawyers this afternoon. Mr. Buxman, explain to me why the facts to which he pled, and they're contained in the plea. Let me have that plea agreement back, Mr. Lenneman.
Oh, I'm sorry, Judge.
Thanks.
I was walking out the door with it.
Yeah, that's why I'm taking back my exhibit. Mr. Buxman, the facts that he pled to here, or the facts that are in the plea agreement, don't contain any of the facts that you're trying to get into evidence. Or let me rephrase that. You're trying to use to make this a prior violent felony aggravator. So why do you get to use facts that weren't pled to?
Because that's what the Florida Supreme Court has indicated. In Johnson v. State, you addressed the burglary issue before. Johnson v. State, 465 Southern 2nd, 499, Florida Supreme Court, 1985, which came out after the Mann case provided to you by the defense. In that case, the defense complained to the trial court instructing the jury that a burglary constituted a felony involving the use or threat of violence to a person pursuant to the prior violent felony aggravator. Florida Supreme Court said, simple burglary is not per se a crime of violence, but burglary may involve entering a place with the intent to commit a crime of violence or may in fact involve violence in the course of its commission. Thus, whether a person convicted of burglary constitutes a felony involving the violence under the prior violent felony aggravator depends on the facts of the previous crime. Those facts may be established by documentary evidence, including the charging or conviction documents, or by testimony, or by a combination of both. Similarly, in Gore v. State, 706 Southern 2nd, 1328, Florida Supreme Court, 1997, 15 years after the Mann case, which was provided to the court, the defendant complained to the trial court erred when it allowed a prior conviction for armed trespass, which in and of itself has no indication of violence towards a person. They were complaining the court to let that in as a prior violent felony. The Florida Supreme Court said, in upholding the trial court's finding that qualifies as a prior violent felony, the court said, quote, testimony concerning the armed trespass offense established that Gore was found crouching behind the front seat of a woman's car with a loaded gun and a police scanner. The woman who discovered Gore upon returning to her car, but before getting in, summoned a police officer and Gore was apprehended. It's clear that at a minimum, the woman was under a threat of violence. We have held that lack of any actual violence or harm to the intended victim is irrelevant for purposes of this aggravator. So there's a variety of cases which indicate that it is not the name of the charge, it is the facts that go into what happened in that charge. Another case that I briefly mentioned earlier, Anderson v. State, 31 Southern 2nd, 390, Florida Supreme Court, 2003. The state wanted to use a prior violent felony conviction of attempted sexual battery on the defendant's wife's daughter. This was the same, I believe this was the same girl that ended up being a victim of the subsequent murder. The state wanted to use the prior conviction for attempted sexual battery, which inherently in and of itself is not a crime of violence because it's an attempt. The defense claimed you can't use it because he pled to an attempt. The court said, no, you look at the underlying facts, and the underlying facts, as alleged in the evidence presented to the court handling the death penalty trial, was that there was penetration involved in the sexual battery, and it was pled down to an attempt for purposes of plea negotiation.
Which one of the cases is that one?
That is Anderson,
I'd like to distinguish those.
841 Southern 2nd, 390, Florida Supreme Court, 2003. And the Florida Supreme Court upheld the use of that as a prior violent felony because, again, you looked at the underlying facts of the crime. In this case, I think the underlying facts of the crime, even in the light most favorable to the defense, shows that a factual scenario involving violence to another person, or at least an unwanted touching to another person, occurred.
Okay, thank you.
Thank you, Your Honor.
Can I be heard in
Mr.
rebuttal?
Livengood, hold on. Give me a minute to think.
Just
All right, this is the last thing I'm going to hear on this. Go
all
ahead,
right,
Mr.
just
Livengood.
a note on Johnson. It's got a severe negative treatment.
What?
Johnson, the case he cited, has a severe negative treatment. I don't know on what part of the case. I haven't looked, but it really doesn't matter. Because here's the issue. He keeps going back to issues where there is a factual connection. So attempted sexual battery and the penetration, a burglary and the violence. Here we have a situation where he was charged with something that is not even factually true. The fact that someone was picking up somebody, my client, and throwing him down when he is charged with mutiny, and the clear underlying explanation of mutiny is several inmates. That how they can jump over that, Judge? It's like on the sexual battery and the person pled to a simple trespass. I think that that's a distinguishable issue, and I think you can do that with every case. This was a plea to something disconnected with the original plea, factually and otherwise. And there is no factual upholding the issue that you're going to use these facts of this act of violence and put them in a box where my client pled to something that has nothing to do with that and is distinguishable by the issue of taking several inmates, Judge. I mean, you have to just brush that over to be able to say that that would be considered a mutiny, and I think that's incorrect.
Am I correct that none of you has the PSI that was filed?
What, I'm sorry?
Have the PSI that was filed?
I attached it to my motion, Your Honor. I believe it's Exhibit A.
Oh, okay. Let me take a look at all that. I'll get you guys a ruling in the next couple of days. You don't need it right now.
And if I could address just the claim of Johnson has severe negative treatment.
My staff lawyers just told me that it's on a separate issue.
Thank you, Your Honor.
Thanks, yeah. The case was not overturned. It's just a separate issue. All right, let's move on to jury instructions. Everybody have a copy of the very preliminary ones that you sent me?
Yes, Your Honor.
What? All right. I'm hanging on to this exhibit for purpose. I'll give it back to you tomorrow or the day after, but I'll make sure that we don't write on it. Not that I have not been known to do that before. Oh, let me see that too, yeah. Let me have that one, yeah. Let me see this statement this officer made. No, you can just do it as number 2. It didn't have to be identified in any way. All right, 3.1, any objections?
Hold on a second, Judge, I gotta pull this up.
Mr. Buxman, can you forward this? Oh, wait, State's handing you a paper copy. Thank you, Mr. Williams. All right, 3.1, I assume no one has an objection to. 3.2, statement of the charge. This is very preliminary, folks. We'll have to do a charge conference again later. I don't see any issues with that one. .1, introduction to homicide. Any objections at this point to 7.1, defense?
No.
7, all right, justifiable homicide. That seems to be the standard. Excusable homicide,
Judge, justifiable?
justifiable homicide.
You're requesting,
I can't hear you, Mr. Linneman. You've got to turn your mic on.
Judge, we would be requesting a heat of passion instruction.
Do you have a proposed instruction
I
on that?
do.
Okay, have you given the state a copy?
I got an email.
Okay, thanks. You want this given as part of justifiable homicide?
Well, it's going to have to be after, I guess, the murder charges. I wasn't sure where you place it, Judge.
Yeah, justifiable, I don't believe that even if given, justifiable homicide is not where this is given unless
Okay.
they've,
The standard jury instructions, I believe, put it at the end of each individual charge.
yeah, this is, Yeah, this is, so justifiable homicide, do you have any objections to that standard instruction?
No.
Excusable homicide,
No.
okay. All right. Count 1, first-degree murder of a law enforcement officer. All right, this appears to be the standard instruction. Any objections?
No, I don't think so, Judge, but I just need to check back.
Yeah, this is just preliminary right now. I'm just checking for things that jump out at us. 6.1, introduction to attempted homicide. This is attempted first-degree murder of a law enforcement officer. This appears to the court to be the standard instruction, as
Yeah.
does justifiable attempted homicide and excusable attempted homicide. At the moment, do you have any objections to it?
No.
Okay. Count 2, attempted first-degree murder of a law enforcement officer. I think this one's kind of out of order. No, I'm sorry, it's not. All right. Markeith Carter. This appears to me to be the standard.
Yeah, I agree, Judge, but I get to go back
Okay,
and
so
look.
at this time, I'll just let it be. Count 3, aggravated assault.
Yeah, I think, but I have to look.
Yeah, this appears to be the standard. So count 4, carjacking.
Again, I think that's a standard, Judge, but we'll have to double check. Yeah.
Yeah, I don't see anything jumping out at me. It appears to be the standard. Count 5, possession of firearm by convicted felon. You'd have to take the italics out, obviously.
I will, Your Honor.
Yeah.
That was a note to me that was still uncertain.
Yeah.
That's fine, Judge.
Okay. All right. Then we have lesser, in 3.4, lesser included crimes. So for count 1, we have first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter. Any others defense is requesting?
Yeah, we're asking for that heat of passion instruction.
No, these are lesser included.
Oh, okay.
Heat of passion isn't that yet. I'm getting to your heat of passion. I just want to go through these first, and then we'll talk about it.
Yeah, I have no objection to this.
Okay. So then we have first-degree murder as to count 1. This takes out the law enforcement portion of it.
Is this the order, Judge, or is it supposed to be right after the?
I haven't checked. No, I normally read all of them, and then I read the lesser includeds, and I do one at a time.
Okay.
Take count 1, all the lessers, count 2, all the lessers.
Okay.
There's so many instructions in this case, if we keep it organized, I think the jury can keep it organized. So I don't see anything on this first-degree murder. It appears to be the standard. But I'll certainly give you time to check that. So then we have second-degree murder of a law enforcement officer.
No objection.
Second-degree murder, taking out the law enforcement officer issue.
Objection.
Okay. Then we have manslaughter.
No objection.
All right, so now we have 3.4 as to count 2, attempted first-degree murder of a law enforcement officer. So right now we have attempted first-degree murder, attempted second-degree murder of a law enforcement officer, attempted second-degree murder, and attempted manslaughter. Are any other lessers requested at this time by the defense?
Not at this time, Judge.
All right, attempted first-degree murder as to count 2, removing the law enforcement officer.
No objection.
Okay. Attempted second-degree murder of a law enforcement officer.
No objection.
Attempted second-degree murder.
No objection.
Attempted manslaughter by act.
No objection.
All right, 3.4 as to count 3, aggravated assault, improper exhibition of a firearm, and assault. Any other lessers requested at this time by the defense?
No.
10.5, improper exhibition of a firearm.
No objection.
Assault.
No objection.
Lesser included attempts as to count 4, carjacking, listed are robbery and grand theft of a motor vehicle. Any other lessers requested at this time by defense?
No.
15.1, robbery.
No objection.
$14.1, grand theft of a motor vehicle.
No objection.
3.3, subsection D, possession of firearm, discharge of a firearm or discharge of a firearm causing great bodily harm or death.
Judge, is that right on the first paragraph?
It reads really strangely, but that is the standard. It sounds as if we're directing them to convict him of everything. It's just weird.
Well, I have an objection to that at this time.
You have what?
An objection at this time.
What is your objection?
This, if you read the jury instruction, it re-emphasizes that you should find the defendant guilty of first-degree murder of a law enforcement officer. We've already had that instruction, and that instruction has like 6 elements.
This is I'm not saying that the English in this instruction is the best. I'm saying this is the standard jury instruction for this.
All right, well, I still
And
make an
it
objection.
says, you know,
I'm just
what-
objecting for the record.
okay. So, any objections to the next paragraph?
Just gets worse.
It just, that's the way the instruction reads. So your objection is to the line, you should find the defendant
Well, I
guilty of-
think you're correct. I mean, it does get worse.
Okay.
So the whole thing.
Are you objecting to the entire instruction or the line that reads, you should find the
The
defendant
entire
guilty?
instruction.
The entire instruction, okay. Do you have, at this time, a proposed alternative instruction?
I got to first understand what they're trying to say, Judge, because it seems like they're trying to say you should find the defendant guilty of first-degree murder or second-degree murder or second-degree murder, law enforcement, attempted first-degree. It doesn't make sense why they're stacking that.
You have to read, yeah, I mean, I've read this many, many times in many, many trials. I understand what you're telling me, but this is the standard instruction directing them that if they find him guilty and they find beyond a reasonable doubt that he discharged a firearm and caused great bodily harm or death to Debra Clayton, then you should find him guilty of whatever crime it was they found him with discharge of a firearm causing great bodily harm or death. That's what each one of these paragraphs means.
I mean,
And then it goes on to say possession, then there's discharge without great bodily harm, then there's possession.
I don't understand why it can't be so much more simple.
I wasn't on the committee that wrote this. I don't have an answer for you. This is the standard instruction.
All right, my objection.
So I've noted your objection.
Thank you.
All right. 3.3, aggravation of felony by carrying a firearm. Did we even read attempted manslaughter by act?
It's a lesser of count 2.
No objection.
Attempted first-degree.
Is it, I don't remember it being added.
It's the 4th lesser under count 2, attempted murder of a legal.
It may very well be at this point, I've forgotten what the lessers were on some of this. So as long as it's in there, I have no problem with it. Okay.
Third copy.
Personally carried, displayed, used.
Print it out. Maybe I'll let us keep it. I'll give it to you.
Any objections to this one?
Thank you. No objection. Yeah, that's what you're saying.
3.6, insanity.
No objection.
Okay, the italics portion of this, you're going to take out the italics.
Take it out.
Yeah, I'm not crazy about italics or bold. In,
No, I mean the language itself. I looked
Oh.
at it as italics because I wasn't sure if that was going to be included.
Let's read that. It says, a defendant who believed that what he was doing was morally right is not insane if the defendant knew that what he was doing violated societal standards or was against the law. Unrestrained passion or ungovernable temper is not insanity, even though the normal judgment of the person is overcome by passion or temper. Since you're requesting a heat of passion instruction, that would mean that I would need to read this.
Okay.
All right, so leave it in.
Yeah. And what about the last one, last paragraph?
Which one?
about that he may not go to be released from
Oh,
custody?
I hadn't gotten to that page yet. If your verdict is the defendant is not guilty, he will be released from custody. Yeah, we're going to take out the words "or released" out of this because he's not being released.
Take out the entire last paragraph.
No, I mean, we can if you want to. If your verdict, it's up to the state. What do you want to do with it? And this paragraph, for the record, is if your verdict is that the defendant is not guilty by reason of insanity, that does not necessarily mean he will be released from custody. I must conduct further proceedings to determine if the defendant should be committed to a mental hospital or given other outpatient treatment or released.
In light of what we have told the jury, that he's already convicted and sentenced to life, I don't see the need for that paragraph.
Defense?
I agree.
Okay.
I just leave it open because I have to talk to my clients more about it.
All right, so we're going to leave it in italics. I'm marking it as coming out unless I hear differently from defense. And then I'll rule at that time. So it doesn't appear to apply in this case at all, and we have told the jury repeatedly that he's been sentenced to life without parole. All right, 3.6H, justifiable use of force by law enforcement officer. Any objections?
I do, Judge, but I need to research it.
I'm sorry?
I just need to research this issue. I mean, if it's the standard, and it applies factually, obviously I won't object, but I just need to take a look at it closer.
Okay. Well, like I
leave it in
said,
for
this is
now.
all of this is preliminary. All right, let me make sure you guys change this. You must find the defendant. Okay.
You know what, Judge? I will, I agree to 3.6H.
You're not objecting to it?
I'm not objection.
Okay. 3.7, reasonable doubt.
No objection.
Three 3.8, evidence of other crimes, wrongs, or acts, Williams rule.
No objection.
3.9, weighing the evidence.
The only one I removed was the intent dealing with reputation. I think there is going to be
Which one did you remove?
reputation.
Okay.
All right, 1 through 4, 5, all those are normal. 6, has the witness been offered or received any money, preferred treatment, or benefit in order to get the witness to testify? Is there any evidence of this at this stage?
We're going to have a lot of experts being paid.
Oh, I forgot about those. Okay, we'll leave that in. Pressure or threat been used against the witness?
Well, yeah, I mean, I'm alleging, and I'm going to call Mr. Sturby in my...
You're going to call who?
Sturby, remember the guy?
Oh, Sturby?
Yeah, I'm going to call him. And there's
Okay.
some
All right, so
kinda
we'll leave that one in.
fishy stuff.
And then inconsistent statements, we've had that come up, and we've had a witness who's been convicted of a felony. All right, any others? 10 doesn't apply, so.
No.
All right, the testimony of a witness who helped the defendant commit a crime or has been promised immunity, is anyone anticipating said testimony to come out?
The only reason I left that in is because if Mr. Stribby, Brian Stribby, testifies at the first trial, there was an allegation made by the defense that he received some kind of deal for his testimony. There's no factual basis to support that, but that information was brought out.
All right, so I'll leave that one in for right now. We'll see what Mr. Stribby says on the stand.
And so you're not confused, Your Honor, I put the 3.9 instructions in there, one has a paragraph up and a testifying, one's not.
Okay, thanks. All right. 3.9, defendant not testifying. If that one is read, do you want both paragraphs read, Mr. Lenneman?
That's fine.
Okay. (3.9) defendant statements. There haven't been any so far. We'll leave it here, just in case. 3.10, rules for deliberation.
That's a standard, right?
You took out the one about jurors asking questions, right?
I did, Your Honor.
Okay. Cautionary instruction, 3.11 is the standard. Verdict, 3.12.
That's fine.
3.12A, single defendant, multiple counts. That one's standard. 3.13, submitting case to the jury.
I wasn't sure how you handle the cell phone issue.
Yeah, I'm going to take it out because the deputies have their cell phones and they're not here. Any objections, Mr. Lenneman?
No.
Okay. Okay, that statement, these exhibits will be sent into the jury room, they will not. The guns aren't going back, so that needs to be changed. Some exhibits will be sent into the jury room.
And you're going to, this is a stupid question, but you're going to specially explain to them the process if they need to see a video.
Yeah, that's what I'm going to say right now. So
Okay.
some exhibits will be sent into the jury room with you when you begin to deliberate. If you need to see other exhibits or a video, and I usually verbally tell them we don't send the firearms back unless they ask for them. Other exhibits or a video played. Please request that in writing. In writing. You know what, change that to, or a video played, they will be provided upon request. I want to make it clear to them that we will give them what they need, yeah. All right, let's take a quick look at the verdicts. Count one. Any objections at this time, Mr. Lenneman?
No.
Count two. Any objections?
No.
Count three. Any objections? Is he raising insanity as to the carjacking, the attempted murder? I thought he was raising insanity just as to Lieutenant Clayton. Or is he raising it as to everything?
No. Judge, I just want to raise it to the first degree murder.
I'm sorry?
Just the first degree murder.
Yeah, I don't think insanity is being raised as to count 2, 3, or 4. And count 5 would not be subject to an insanity defense.
Okay. Yeah. He wants to talk with me about it, Judge, so we just leave it open.
All right, so we're tentatively crossing it out, but don't take it out yet. All right?
Okay.
And then count 5 is the possession of firearm by a convicted felon. Are you raising insanity as to that one? Or is that the same answer? You want to talk to him a little bit?
Yeah, we need to talk about all this.
All right, I'll just kind of lightly accost him. Then we have the special findings.
Carjacking.
Count 1.
No objection.
Count two. They seem to be the standards. Do you have any objections to them at this time?
No.
All right, let's take a look at the requested heat of passion instructions. Is this the standard or is this one you came up with? Mr. Lenneman?
What, Judge?
The heat of passion instruction here, let me take this off.
Correct.
The heat of passion instruction you gave me, is that the standard heat of passion?
No.
The one that you drafted?
So,
Okay,
Ms. Miller drafted it.
right. So I'll say one the defense drafted.
Yes. And then I also have one that's tentative, depending on circumstances.
I'm sorry, what?
I have one more that's tentative.
Okay, let's start with heat of passion. State, have you had a chance to review this? Did you bring a copy?
No, I
for
haven't
State?
been able to email it to him yet, Judge. Can we just put those on hold until we talk again?
You can take a look at it right now if you'd like. While I read this justifiable use of deadly force.
I'm ready to just send it to you in email.
Thank you. The language in the proposed heat of passion does appear to be standard in the jury instructions for each of the counts.
Okay.
Not
And
saying
then here's the
agree
just-
with it or that we think it's appropriate, but they are the same.
You guys read that one? Have you, the justifiable use of force one, all right. The heat of passion instruction, I assume this would be an alternative defense? I think he gets it. I don't know that this is the correct wording. State, you want to be heard on this? It would be an alternative defense.
I got one more, Your Honor. At this point, Your Honor, I don't know if we have evidence in the record to support giving the instruction. I think we need to table this, let us do a little bit of research and wait until some of the facts are brought out further.
Yeah, I should clarify. I'm not really ruling it's in. I'm saying if there's evidence in the record, even a scintilla, when we're at the end of the case that supports this, then he would get the instruction as an alternative defense.
Yes, Your Honor.
That's a much better ruling than what I just said, but it's been a long day.
I'm sorry, Your Honor.
So, no, that was on me. So we'll table this for the next jury instruction. And I need to check the language. It does look like the standard, but I haven't checked the language, so I'll check that. And then we have the justifiable use of force by Mr. Loyd requested instruction.
And my response will be the same.
Okay. Yeah, that is just the standard instruction, but with Mr. Loyd, the only question I have about that one is the stand your ground portion of that. Mr. Loyd is a convicted felon in possession of a firearm. He is legally not entitled to a stand your ground instruction, and I would not read that portion of it unless you have some case law that it's changed.
No, I think, I'm talking to Ms. Miller, my research.
Can't hear you. What?
Let me talk to Ms. Miller, but my preliminary research agrees with the court.
Yeah.
The court.
I don't think he's entitled to that portion of it. So, Dave, if I could, you're going to email them this, right?
I just did.
You have them, if I could have my written one back. Are you done with it when you're done?
I am, Your Honor.
Okay, thanks. All right, anything else on, let me try that again. Anything else on jury instructions? Or anything else that we need to discuss?
Not from the state at this time. No, never mind. Apparently, Mr. Williams has something.
Of course he does. Mr. Williams, what can I do for you? Go ahead.
The way that was said, I just don't know. I spoke to Mr. Linneman late morning about some of the witnesses. He's informed us of the witnesses, and I think we discussed it at a bench conference that we're trying to help him coordinate some of the witnesses.
Okay.
It's the state's position that several of those witnesses do not have admissible evidence. And I believe Mr. Linneman is in agreement that we can resolve that, if possible, today, to prevent those people from coming in, getting on the stand, us raising an objection, and then having a break in rule.
Okay. Go ahead.
So it's the state's understanding that the defense intends to call crime scene investigator Ed Vanderberg, specifically for the purpose of admitting the letters that were found at the Lescott Lane address that Mr. Loyd had written. It's the state's position that they are self-serving hearsay that does not meet an exception and that they should be excluded. That is the only purpose for Mr. Vanderberg's testimony, that his testimony should not be permitted.
What's in the letters?
His version of the events of the Dixon murder, for the most part. And I'm happy to listen, obviously, to defense counsel if they believe that there's specific portions of it that are relevant or meet an exception. But generally, it's, I believe, 7 or 8 pages of his explanation for what happened the night of December 13th.
Okay. Mr. Linneman, what are you admitting these letters for?
We call it his manifesto, Judge. It was written while he was in the building where he ended up.
Do you have your mic on?
Better?
Yes, much better. Go ahead.
We call it a manifesto that he prepared while he was, just before he surrendered on this issue. So he had been on the run since Lieutenant Clayton's murder. And it is a narrative of material that collectively and individually go to his state of mind at the time of leading up to his arrest, but including things that had occurred between Dixon and leading up to the Clayton murder.
And
So-
why would he not be required to take the stand and testify to that if he wants it in evidence? What would be the exception that would allow written statements by a defendant into evidence?
Okay, so I agree with the court. He will testify, but I need a predicate to establish, because he's the one, unless they agree by stipulation, he's the one, Vandenberg is the one who collected it at the house.
So all you're putting this gentleman on for is to say that he collected these letters at the house?
It's not a letter, it's one letter.
Oh, I'm sorry, okay.
Yeah.
But he collected, I remember some papers in the photograph.
Yeah, and I crossed him on it, but, I couldn't introduce any of that or ask him about that.
And then later on, you're going to try and lay a predicate through someone else to get it in?
Yep.
State?
Judge, we would stipulate that those letters were found at the Lescott Lane address by
That's fine.
Mr. Vanderburg.
All right, so can that witness now be released and excused?
Yes.
All right, you may release Mr. Vanderburg?
Vanderburg, yes, Your Honor.
All right. Who's next?
Detective Michael Moreschi and Detective,
Can I ask one more question?
yes, sir?
We have and I don't know if the state agrees on this, we have a handwriting expert who looked at those way back when we were dealing with the Dixon case and compared those to Mr. Loyd's handwriting, and he would testify that they're one and the same. I don't know if it's also a predicate before I bring it in through other parties.
Judge, state would stipulate that as to the letters found, that Mr. Loyd authored them.
Okay.
Okay, perfect.
And we're talking about the ones found inside the Lescott Lane house
Correct.
that can be seen laying on top of the makeshift bed? Is
Right.
that correct?
But they're going to have to bring it because I don't know if they brought it over already.
We'll make sure it's here.
Okay.
Okay?
All right, so the handwriting expert does not need to testify.
I will let it release him.
All right.
Anything else?
Not as to that witness. I was moving on to the second witnesses.
Oh, yeah, go ahead.
Detective Michael Moreschi and Detective Michael Fields. My understanding is that they would be called to admit at least one call or transcripts of a call intercepted between Mr. Loyd and other witnesses where Mr. Loyd references potential of surrendering. Our objection is the same, that it's hearsay, it's inadmissible, and that therefore these witnesses do not need to be called.
Mr. Lenneman?
Yeah, it's non-hearsay, Judge. There is material within those calls that go to his state of mind. There are actually 3 separate calls. I have a transcript I can email the court, which is 17 to 19 pages if the court wants to view that in regards to that issue. But I plan on calling them because, as you remember, there was a whole issue about wiretaps. And the only people that we got wiretaps through was the state attorney, and it was done kind of in a way that they only let us know about 2 people who were involved in that particular.
What does that have to do with the admissibility of these wiretaps? Because
That
it's
goes-
the content that, it's not the wiretaps themselves right now.
Right,
The
right.
issue, it's the
Right, it
content.
goes to his state of mind. It's not hearsay. It's not being offered for the truth in this particular.
What is it being
portion.
offered for?
I'm sorry?
What is it being offered?
His state of mind.
What state of mind?
His state of mind at the time of the wiretaps, which is important, as is his state of mind at the time that he's giving up and surrendering, because he's still continuation of his mental illness. And there's evidence within those calls that I support that. So it's non-hearsay.
What specifically? I mean, you can send me 17 pages, but if all you're trying to admit is 5 statements that go to his state of mind, then just tell me what they are, and then
Yeah,
send me the
I
17.
don't have that information right now on me, but
Okay.
and if they would agree to stipulate to those coming in, subject to their objections, so we don't have to call Moreschi and Field, then we can call off Moreschi and Field.
Your Honor, the issue, Mr. Moreschi lives in North Carolina,
Doesn't what?
lives in North Carolina
Right.
and is retired.
Okay.
Detective Fields can come in, but tomorrow is when this is going to happen, and we don't know what the statements are. The only statement that I have ever seen that has become relevant to anything, and that's relevance according to the defense, is Mr. Loyd's statements about turning himself in. And they're just not relevant. And state of mind exception is 90.803 sub 3. His state of mind at the time of apprehension is not a material fact in this case. So I'm happy for Your Honor to review the calls, but we are unaware of any exception that they would meet.
Well, the turning himself in is not relevant to any material element of any of these crimes. That's just not in the guilt phase.
Correct.
We're just talking about guilt phase.
I agree.
So turning himself in, none of that's coming in, all right, right now. I'm just talking about guilt
Right,
phase.
but here's the situation, it actually is relevant, and the state made it relevant, because they put these Facebook pages in that say, oh, Mr. Loyd, what are you talking about? He wants a police officer, and he's venting about some of those things. They put that issue in play, and so this is important to rebut that issue.
Turning yourself in and Facebook statements about harming police officers are two completely different things. I'm not seeing the connection. I don't see what turning yourself in has to do with
Well,
Facebook statements about wanting, I mean, let me be blunt, about wanting to kill police officers.
so imagine that Mr. Loyd gets up there and he explains in detail what was going on when he made those 3 Facebook page activations. And the jury says, oh, you know, that's reasonable, I guess, or maybe I need to know something else, that he's going to turn himself in. Oh, yeah, then, you know.
That's not relevant to the guilt phase. I'm not letting in statements about turning himself in.
All right, let me look through and see if there's anything else.
And again, these rulings are all guilt phase, all right? Okay, so next.
So just so I'm clear on this, we had agreed, Mr. Williams and myself had agreed for Mareshi to appear by Zoom and not have to travel down here if he was going to testify. And that was that's still my intent, subject to the court excluding the whole phone call. So I just want to make sure.
We still agree on the Zoom issue. The issue is whether or not he can testify at all about the content he's going to be asked about. If he needs to appear because the court rules that he has admissible evidence, then we will make him available via Zoom.
Yeah, and all I'm saying right now is I don't need to hear from anybody about turning himself in. If there's some other statement in there that you believe is relevant to the guilt phase, happy to look at that. Okay. Next.
Detective Brian Cervelli, we believe will be called for the purpose of attempting to admit a press release from the Orange County Sheriff's Office regarding the Dixon murder, which we do not believe is relevant to any material fact. And if that is the only reason for him being called, we would ask that he not be called as a witness.
What are we calling Cervelli?
That's incorrect, Judge. Because he testified, we called him at the last trial, and we didn't try to introduce a press release, nor are we going to try to introduce the press release now.
So you're calling Cervelli for another purpose?
Yeah, so that was being called for the issue of that he had contact with my client's niece, and there was that whole thing about the news, as we pointed out earlier.
But that goes back to the turning himself in. What's the relevance of that?
No, not turning himself in, his state of mind, that he decompensates when he finds out that this issue happened where the priest had.
Is this before or after Lieutenant Clayton is shot?
This is before.
Okay. All right, you're right. He did testify to all that.
Right, right. And so all we're putting it in for is to show that he decompensated, and that was one of the issues where this whole piece of trying to kill me all began.
You do realize,
Yes.
and I know you realize this, Mr.
Yes.
Lenneman, that Detective Cervelli's testimony may open the door for rebuttal by the state on facts surrounding the Dixon homicide.
I know that was your ruling previously.
Okay.
Well, Judge, just so everyone's aware, I'm assuming defense is aware that Detective Cervelli would testify that during those conversations, he begged and pleaded with Mr. Loyd's family to have him turn himself in peacefully. So that's going to become relevant. We don't believe it's relevant, but I understand the court's ruling, and if they want to call him, then...
Well, I'm not expecting him to get up there and the defense to start eliciting testimony about Mr. Loyd turning himself in, because I've already said that's not relevant. He's telling me he's going to put him on there solely for the issue of the press, Mr. Loyd's belief that the press was, and the police were pushing, I can't remember if it's both of them or one of them, were pushing a false narrative, and that is tied into his insanity defense, is
Right.
my understanding of this.
And how could Detective Cervelli possibly provide that testimony that's not
He
hearsay?
cannot tie it to the insanity defense, but he can provide, I mean, I guess I have to hear the testimony. He's not a clear-cut no to me at this point. He did testify in the first trial, although, quite frankly, I don't remember what he said.
The only request we would make is on that witness, we proffer his testimony.
That's fine, I don't have a problem with that.
Yes, Judge.
Just proffer him quickly beforehand? Okay. What else? Oh, you're the one making the objections. Go ahead, what else?
Lieutenant Douglas Gerke, actually Captain Gerke, was with the Orlando Police Department. It's our understanding that he's going to be called to say that he played a role in bringing Lieutenant Clayton's handcuffs to the apprehension scene and handing them to officers so that they could put them on Mr. Loyd.
Part of our theory, Judge, is OPD has a bias process that's already been in place since the shooting of Lieutenant Clayton, and this was one more piece of the puzzle that they decided from higher up than Gorky, because he says that in his depo, that they were going to use these handcuffs and take the old handcuffs off and put the old handcuffs in. So it's clearly showing bias of the OPD.
Bias by an agency or bias by a particular officer that is testifying?
Well, he won't say it's Chief Mina, but that's who I believe it is.
So bias by an officer that is not testifying?
Biased by the chief of police who oversees the entire police department and is responsible for the men under him.
I'll grant you that it shows anger at the death of Lieutenant Clayton. I'm not clear why it shows bias.
Well, I think in the original approach on this issue, our attempt has always been to remove the curtain from what was really going on. That includes the beating of Mr. Loyd by 4 OPD officers. That includes the 2 detectives, including Cadiz, sitting in front of him while he bleeds profusely for an hour and not getting him any medical attention. The handcuffs are just another piece. So it was our intent from the very beginning to put all that stuff off, and I know the courts have ruled against us on.
It's not relevant to guilt phase. These are all things that are not relevant to the essential issues or the essential elements of the crimes with which he's been charged. I don't see that this officer's testimony, he's not an investigating officer, right? He has not been called as a witness.
Correct.
Bias goes to a specific witness on the stand, not to people who haven't testified, aren't being called. So if that's all he's testifying to, I'm afraid the state is correct, that testimony would not be allowed.
Over our objection.
Over your objections, yes. Next.
That's all.
All right, anything else we need to talk about before tomorrow morning?
Well, my client has asked me to read some things into the record.
He wants you to read some things into the record?
Yes.
Sure, go ahead.
Okay. You want me to read that? All right. The only thing we want to put forth is that Markeith came to the house, flashed the light on Ron's window, and knocked on the door. Ron answered and called Sade to the door. Sade and Markeith walked out to the cars. Dominic gets dropped off and goes in the house. Sade goes in the house a while after Dominique, in 20 or so minutes from the time Markeith arrived and she came out. Sade went up to the stairs and came back out eventually. Ron comes out and and the incident, it happens. We are not going into details of the incident. We're only putting forth to the state of mind of the defendant as to the report was told to the news and public that Markeith just came over to Sade's house, banged down the door and gunned her down, which plays into the state of mind of Markeith, because what the news reported was not true of what happened, and detectives had the statements of Ron and other family members, but report a false story to the news. Okay.
Is that it?
Yes.
Okay, thank you. All right, we're in recess until 9:30 tomorrow morning, where we're going to start with the defense's case. I'll get you all a ruling on the aggravator in the next couple of days. All right, court's in recess. Let me talk
Judge,
to
one
you.
more thing he wanted me to say, that
Sure.
goes to his state of mind.
Okay, thank you, Mr. Letterman. All right, folks, let me see the attorneys for a minute.